Case 1, Nytosha Laforce. Winooski, Vermont, Chittenden County Superior Court. April 4, 2014. Winooski is a small city that sits just north of Burlington, Vermont's largest city, separated from it by the Winooski River. The name Winooski itself comes from the Western Abenaki language, a reminder that the ground beneath this modern urban community carries a history far older than any courthouse or police department. It is one of the most densely populated communities in Vermont, a compact and energetic city of just over 7,000 residents packed into less than 2 square miles of land on the south bank of the river that shares its name. For a city of its physical size, Winooski carries a remarkable amount of civic life: schools, community organizations, a revitalized downtown circle, and a population that is more ethnically and linguistically diverse than almost anywhere else in the state. Vermont is not a state typically associated with urban density or demographic diversity. Its population is predominantly rural by national standards. But Winooski stands as an exception, a small city that has become home over recent decades to large communities of refugees and immigrants from Somalia, Bhutan, Vietnam, Bosnia, and dozens of other countries, many of them drawn to Vermont through formal resettlement programs supported by local organizations. This diversity gives Winooski its particular energy and its particular character. The social services infrastructure in the city has had to grow and adapt constantly to meet the needs of a changing population, and the community organizations that serve the city have developed genuine expertise in navigating complex family situations across cultural and linguistic lines. It is the kind of place where people notice things, where neighbors are close enough to hear what is happening next door, where emergency vehicles arriving on a residential block are seen and noted, where the emergency response network is tight, well-practiced, and fast. On the morning of April 4, 2014, that response network was put to the test in a way that would result in a criminal investigation and a case that the Winooski community has never forgotten. Shortly before noon that Tuesday morning, emergency services in Winooski received a call reporting that a toddler had stopped breathing. Dispatchers activated a response immediately. First responders arrived at the address within minutes. When they entered the residence, they found a 14-month-old boy, identified in subsequent court records as Peyton Giroux, in a state of medical crisis. Emergency personnel began life-saving procedures immediately and prepared the child for transport. Peyton Giroux was rushed to the University of Vermont Medical Center in Burlington, the region's primary trauma and pediatric care facility, a Level 1 trauma center with one of the most comprehensive pediatric programs in northern New England. The medical staff worked with urgency and skill to stabilize the child and assess the full extent of his condition. Despite every effort, Peyton Giroux did not survive. He was 14 months old. The death of any child carries a weight that is impossible to fully put into words. The death of a toddler, a child at the very beginning of his conscious experience of the world, a child who had only recently begun to walk and discover his surroundings, represents a loss of incalculable magnitude. Peyton Giroux had barely begun. He was at the age when children are learning the names of things, when the world is expanding before them in ways both wonderful and overwhelming. He never got to finish that discovery. From the moment Peyton arrived at the hospital, the medical professionals who examined him were documenting everything they observed with careful precision. In pediatric cases of this nature, medical documentation is not simply a procedural formality. It is a critical part of the investigative process. The observations made in those first hours at UVM Medical Center would prove to be foundational to everything that followed. The medical examiner's office conducted a comprehensive examination following Peyton's passing. The findings were detailed and unambiguous. The official ruling was that this was not a natural death. Investigators were informed that the injuries the child had sustained were consistent with harm inflicted by another person, harm that was not accidental and not the result of any known medical condition or unavoidable circumstance. That determination changed everything. The case moved from a medical tragedy into a formal criminal investigation, and the full machinery of Vermont's justice system was set into motion. Investigators with the Winooski Police Department opened a formal criminal investigation immediately. They were joined by the Vermont State Police, whose major crime unit has the expertise and resources to conduct thorough investigations into the most serious cases in the state. The Chittenden County State's Attorney's Office coordinated with law enforcement to ensure that every step of the investigation met the evidentiary standards necessary for criminal prosecution. The investigation was methodical and wide-ranging. Investigators interviewed everyone who had been in contact with Peyton Giroir in the days and hours leading up to the emergency call on April 4th. They reviewed the timeline of events with granular precision, working backward from the moment help was called to reconstruct what had happened to the child. They examined the physical environment of the residence, gathered and preserved evidence, and consulted with medical experts regarding the nature and circumstances of Peyton's injuries. What emerged from that painstaking investigation was a body of evidence that the Chittenden County State's Attorney's Office determined was sufficient to support criminal charges. The investigation had focused on Nytosha Laforce, the mother of Peyton Giroir. She had been present with the child during the period investigators determined was critical. The evidence assembled by law enforcement pointed to her as the person whose conduct had led to her son's death. Nytosha Laforce was charged with second-degree murder in connection with the passing of her 14-month-old son. Under Vermont law, second-degree murder reflects a legal determination that the death was the result of intentional conduct, not an accident, not the result of negligence, not an unavoidable tragedy. The charge carries severe penalties and represents one of the most serious findings that a prosecutorial office can bring before a court. The case proceeded through the Chittenden County Superior Court. The prosecution built its case on the medical examiner's findings, expert medical testimony, and the investigative record assembled by the Winooski Police Department and the Vermont State Police. The evidence was presented through the formal processes of the Vermont court system, subject to the rules of evidence, the requirements of due process, and the full scrutiny of the court. The case drew significant attention in the Burlington and Winooski area. The community that Peyton Giroir had been born into, the compact, diverse, tightly knit neighborhoods of Winooski, processed the news of his passing and the subsequent charges against his mother with the combination of grief and quiet determination that communities bring to losses of this kind. People who live in communities like Winooski understand, personally and immediately, what it means when one of the city's youngest residents does not survive. The loss of a toddler is not an abstraction. It is the loss of a child who was known, or could have been known, to the neighbors and families and community networks that make a small city function. The case of Nytosha Laforce and the passing of Peyton Giroir illustrates something that child welfare professionals and law enforcement investigators across the country have documented extensively over decades of research and practice. The youngest children, those who cannot speak for themselves, who cannot report what is happening to them, who cannot seek help or attract the attention of outside observers, and who depend entirely on the adults around them for their safety and their very survival, are among the most vulnerable individuals in any community. Their dependency is total. Their trust is absolute. And when the adults who hold their lives in their hands choose to harm them, the consequences are irreversible. Peyton Giroir was 14 months old. He had no way to seek help, no means of communicating his distress to the outside world, and no capacity to protect himself. He depended completely on the adults in his life to keep him safe. That protection was not given to him. The Vermont court system, through the combined work of the Winooski Police Department, the Vermont State Police, the Chittenden County State's Attorney's Office, and the Medical Examiner's Office, worked to ensure that the full account of what happened to Peyton Giroir on April 4, 2014 was documented, prosecuted, and entered into the permanent legal record of Vermont. His case stands as a reminder that every child deserves protection, that the systems designed to deliver justice for the most vulnerable among us exist for a reason, and that the work of investigators, prosecutors, and medical examiners in cases like this one is among the most important work that any public servant can do. Peyton Giroir deserved every chance that life could offer. He deserved to grow, to learn, to become whoever he was going to be. He did not get that chance. But his name is in the record, and the Vermont justice system ensured that the truth of what happened to him was not hidden. If this case resonated with you, please take a moment right now to hit the like button and subscribe to Cold Case Hour. Every subscription helps us continue bringing these verified and important stories to light. These are real people, real families, and real communities, and they deserve to be remembered. Case 2 is next. Case 2, Melissa Robitille. Hardwick, Vermont, Caledonia County Superior Court. August 22, 2014. Hardwick is a small town in Caledonia County in northeastern Vermont, a rural community of just over 3,000 residents set against the backdrop of the Northeast Kingdom, that vast, sparsely populated region of Vermont that stretches toward the Canadian border and carries a distinct identity even within the context of a state that prides itself on individuality and independence. The Northeast Kingdom, comprising Essex, Orleans, and Caledonia counties, is the most rural part of Vermont, a landscape of dense forests, working farms, small mill towns, and communities that have weathered generations of economic change with a resilience born of geographic isolation and cultural self-reliance. People in Hardwick look out for one another in the way that people in small rural communities have always had to. Services are fewer. Distances are greater. The nearest major medical facility requires a drive of meaningful length. The rhythms of life in the Northeast Kingdom demand a degree of community interdependence that urban areas rarely require and often cannot cultivate. When a family in Hardwick is struggling, the community tends to know. When something is wrong in a household, the whisper network of a small town often picks up the signal long before any formal system does. It was in this community that, in the summer of 2014, one of the most disturbing child welfare cases in Caledonia County's recorded history came to light. A case that would wind through the courts for years, generate a Vermont Supreme Court appeal, and leave a community grappling with questions about what had happened in a home that many of its neighbors had passed without suspicion. On or around August 22, 2014, authorities were called to a residence in Hardwick. The specific circumstances that prompted the call are documented in the investigative record of the Vermont State Police and the Caledonia County State's Attorney's Office. When law enforcement arrived at the residence, they found the body of 13-year-old Isaac Robitille inside the home. Isaac Robitille was not a typical 13-year-old boy in the sense of physical capability or independence. He was a young man with significant disabilities that profoundly affected his ability to function independently. His disabilities required that he receive assistance with basic daily functions, including nutrition and medication, through a feeding tube. Isaac could not feed himself in the conventional sense. He depended on his caregiver to ensure that his feeding tube was managed properly, that he received the nutrition and hydration his body required, and that no harmful substances were introduced into his system through a mechanism that bypassed every natural protective function of the human body. He was entirely dependent on his caregiver for his survival. Every day, every meal, every dose of medication, every aspect of his physical well-being was mediated through the hands and the decisions of the adult responsible for his care. That adult was his mother, Melissa Robitille. The medical examination that followed Isaac's death was thorough and methodical. In cases involving the death of a person with disabilities in a care setting, medical examiners and investigators must consider a range of possible causes and circumstances. The examination of Isaac Robitille produced findings that moved this case immediately and unambiguously from the realm of natural death or accidental tragedy into the realm of criminal investigation. Toxicology reports conducted as part of the official autopsy revealed the presence of alcohol in Isaac's system. The specific substance identified was vodka. Further investigation by law enforcement and medical professionals determined that the vodka had been introduced directly into Isaac's feeding tube, the very mechanism through which he received the nutrition and care that kept him alive. The substance had been administered through the tube in a manner that bypassed every natural defense of the human body against harmful substances. A 13-year-old nonverbal disabled child, entirely dependent on his mother for nutrition and care, had had alcohol introduced into his feeding tube. The resulting physiological harm contributed directly to his death. This was not a medication error. This was not an accidental contamination. This was the deliberate introduction of a harmful substance into the body of a child who had no capacity to refuse it, no capacity to react to it in the way a person with full physical autonomy might, and no ability to communicate to the outside world what was being done to him. Investigators with the Vermont State Police and the Caledonia County State's Attorney's Office worked with precision and thoroughness through the evidence assembled in the course of their investigation. The toxicology results were clear. The medical determinations were unambiguous. The investigative record pointed directly to Melissa Robitille as the person responsible for what had been introduced into her son's feeding tube in the period leading up to his death. Melissa Robitille was charged with involuntary manslaughter and child cruelty in connection with the death of Isaac. Involuntary manslaughter under Vermont law involves a killing that results from criminal negligence or reckless conduct. Conduct that the law deems so dangerous, so far below the standard of care that any reasonable person in the same circumstances would exercise, that it rises to the level of criminal culpability even in the absence of a specific intent to kill. The additional charge of child cruelty reflects the particular vulnerability of the victim and the nature of the conduct that led to his death. The case proceeded through the Caledonia County Superior Court in St. Johnsbury, the county seat of Caledonia County and the Judicial Center for the Northeast Kingdom. The prosecution presented the toxicology evidence, the medical findings, and the investigative record to the court. The proceedings in Caledonia County Superior Court were conducted with the gravity and seriousness that the death of a child demands from any court system, and they attracted significant public attention both within the Northeast Kingdom and across Vermont. The case generated widespread coverage in Vermont media. WCEX, the Burlington-based television station that serves as one of Vermont's primary news outlets, reported on the case and its progression through the court system. The coverage reflected the community's deep distress at the nature of the allegations and the vulnerability of the victim. Isaac Robitille had been a young man with disabilities living in a small rural community, the kind of community where his situation would have been known to at least some of his neighbors, where his dependence on his caregiver was visible to those with eyes to see it, and where the news of what investigators had determined was done to him landed with particular force. Isaac Robitille was 13 years old. He was disabled. He was nonverbal. He could not seek help. He could not call for assistance. He could not communicate to anyone outside his immediate caregiving environment that something was wrong. He had no physical autonomy and no ability to protect himself from harm. He was, in every measurable sense, entirely at the mercy of the adults responsible for his care, and he depended on those adults to treat his body and his life with the respect and protection that every human being deserves. The Vermont legal system, through the proceedings in Caledonia County Superior Court, worked to hold accountable the person investigators and prosecutors determined was responsible for Isaac's death. The case generated significant public interest not only locally but across Vermont, drawing attention to the particular vulnerability of children and young people with disabilities who depend on caregivers for their most basic needs. It prompted discussions among child welfare advocates, disability rights organizations, and public health professionals about the systems in place, or absent, to monitor the welfare of such children and to ensure that their dependency is not exploited, neglected, or turned against them. The legal proceedings in Caledonia County were not the end of the judicial process in this case. The Vermont Supreme Court records reflect that the case continued through the appellate process, confirming that the legal questions raised by the prosecution of Melissa Robitille were serious enough to merit review at the highest level of Vermont's judicial system. The Supreme Court's engagement with the case underscored its significance within the broader landscape of Vermont criminal law and child welfare jurisprudence. The death of Isaac Robitille on or around August 22, 2014 represents one of the most troubling cases in Caledonia County's modern legal history, not only because of the nature of the alleged conduct, but because of what it reveals about the vulnerability of children and young people with disabilities in caregiving environments. Isaac's case is a reminder that the obligation to protect vulnerable individuals does not become less urgent because those individuals are older, or because their disabilities make them less visible to the public, or because the caregiving relationship that places them at risk is a private family matter. The obligation to protect is absolute. The duty to investigate when that protection fails is equally absolute. Isaac Robitille was 13 years old. He deserved protection. He deserved care. He deserved a future. None of those things were ultimately given to him by the person who was supposed to be the most fundamental and irreplaceable source of all three. His name is preserved in the court records of Caledonia County, and his case is part of the permanent legal record of Vermont. Please take a moment to like this video and subscribe to Cold Case Hour if you have not already done so. These stories need to be told, and your support ensures they reach the people who need to hear them. Case 3 is next. Case 3, Kristie Buzzeo. Rutland, Vermont, Rutland County Superior Court. April 15, 2019. Rutland is Vermont's second-largest city, a community of approximately 15,000 residents situated in Rutland County in the southwestern part of the state, nestled in a valley between the Green Mountains to the east and the Taconic Mountains to the west. Rutland has a history as a center of commerce and manufacturing in Vermont, shaped in large part by the marble quarrying industry that dominated the region for much of the 19th and early 20th centuries. It is a city with a working-class identity, a proud civic history, and the kind of institutional infrastructure, hospitals, courts, schools, social service agencies, that reflects its status as the regional center of southwestern Vermont. The Rutland County Superior Court sits at the center of the county's legal proceedings, handling the full range of civil and criminal matters that arise in a mid-sized Vermont community. It is a court that has processed some of Vermont's most serious criminal cases over the decades, and its judges and prosecutors have developed the kind of institutional expertise that comes from years of working with difficult and complex criminal matters. It was in this court that the case of Kristie Buzzeo was brought before the Vermont justice system in connection with events that occurred on April 15, 2019. The spring of 2019 in Rutland was, by most outward appearances, an ordinary Vermont spring. The slow warming of a landscape that had endured another long winter, the gradual greening of the hills and valleys, the return of longer days, and the particular quality of light that makes Vermont remarkable in the months between winter and summer. On April 15th of that year, a call came in to Rutland Emergency Services that interrupted that ordinary spring with an event of extraordinary seriousness. First responders arrived at a residence in Rutland following an emergency call. The circumstances they encountered when they reached the location were both urgent and deeply disturbing. The scene required immediate medical intervention and set in motion a criminal investigation that would result in serious felony charges against Kristie Buzzeo. Investigators determined through the course of their investigation that Kristie Buzzeo had locked herself inside a bathroom of the residence together with her toddler, her own young child, a child at an age when the world consists almost entirely of the immediate environment provided by caregivers, when a parent's presence is the whole of the known universe, when the concept of danger has no meaning because the child has no framework within which to understand it. Inside that locked bathroom, using a knife, Buzzeo cut the wrists of both herself and the child. When emergency responders reached them, both Buzzeo and the toddler had sustained injuries that required immediate medical attention. Medical personnel intervened rapidly and provided emergency care. The child survived. The fact that the child survived is, in the most fundamental sense, the most important single fact in this case. The rapid response of emergency services, the skill and urgency of the medical personnel who treated the toddler, and whatever combination of circumstances prevented the injuries from being fatal. All of those things converged to produce an outcome that, given the nature of what had occurred, was not inevitable. The child lived. That outcome, as deeply disturbing as the circumstances that surrounded it were, is the outcome that every first responder, every medical professional, and every investigator who worked this case needed it to be. But the survival of the child does not in any way diminish the severity of what happened on April 15, 2019. A toddler was harmed by the person most fundamentally responsible for that child's safety and well-being. The harm was intentional. The setting, a locked bathroom, a confined space from which neither the child nor any potential outside observer could easily intervene, speaks to a degree of deliberation and isolation that investigators documented and prosecutors presented to the court as part of the evidentiary record. A toddler at the age this child would have been has no comprehension of what is happening to them in a situation like this. They cannot process danger in the way an older child or an adult can. They cannot fight back. They cannot run. They cannot call for help. Their entire world, at that developmental stage, is mediated through the presence and the actions of their caregiver, and when that caregiver becomes the source of harm rather than the source of protection, the child has absolutely no recourse. The most foundational relationship in a young child's life. The relationship that is supposed to be the bedrock of their safety, the anchor of their security, the source of everything that sustains them, had become the source of the greatest danger they had ever faced. The Rutland Police Department and the Vermont State Police conducted a comprehensive investigation into the incident. Their findings, combined with the medical documentation of the injuries sustained by the toddler, the forensic evidence gathered from the scene, and the testimony of witnesses and first responders, formed the basis for the charges brought against Kristie Buzzeo. She was charged with attempted second-degree murder, aggravated domestic assault, and reckless endangerment in connection with the attack on her toddler. The charge of attempted second-degree murder is among the most serious criminal charges that can be brought in the Vermont court system in a case where the victim survived. It reflects the legal determination of investigators and prosecutors that the conduct in question was intentional, not impulsive in a legally mitigating sense, not accidental, not the result of negligence or recklessness alone, and that the harm inflicted was of a nature and severity that could readily have resulted in the child's death. The word attempted, in this legal context, does not soften the seriousness of the charge. It simply reflects the factual reality that the child survived the conduct that formed the basis for the charge. The additional charges of aggravated domestic assault and reckless endangerment reflect the specific legal categories that Vermont prosecutors determined were applicable to the full range of conduct documented by investigators. Each charge carries its own penalties, and together they reflect the comprehensive legal response of the Vermont court system to the events of April 15, 2019. The case proceeded through the Rutland County Superior Court. The prosecution presented the physical evidence from the scene, the medical documentation of the child's injuries, the investigative findings of law enforcement, and the expert testimony that supported the state's theory of the case. The proceedings generated significant attention in Rutland County, where local news coverage tracked the case through its stages and where child welfare professionals and community members followed the outcome closely. The case of Kristie Buzzeo raises difficult and important questions that Vermont's courts, child welfare system, and mental health services continue to grapple with across the state. Questions about the intersection of mental health crisis and child safety. Questions about the point at which a parent's incapacity or instability creates a level of risk to their children that demands formal intervention. Questions about the resources available to families in crisis and the systems in place to identify and respond to dangerous situations before they reach a point of irreversible harm. These are not questions with simple answers, and the Vermont criminal justice system is not, and was never designed to be, the primary mechanism for addressing them. But the criminal justice system is where these cases ultimately arrive when prevention has failed and a child has been harmed. Whatever the underlying circumstances, whatever the factors that contributed to the events of April 15, 2019, the Vermont legal system was clear in its determination. The conduct that took place in that locked bathroom on that April evening was not a medical emergency that demanded treatment. It was, in the determination of investigators and prosecutors, a criminal act against a child who had no capacity to protect herself or himself, no means of escape, and no way to seek help. The law exists to respond to that determination, and the Rutland County Superior Court carried out its function. The toddler survived. The first responders reached them in time. The medical professionals who treated the child did their jobs with skill and urgency. And the Vermont court system processed the criminal case that followed with the seriousness it demanded. The child lived. That is the outcome that matters most in the immediate human sense. And the legal record that documents what happened on April 15, 2019 ensures that the full account of that day is preserved in the permanent record of Rutland County. If you are watching this and you have not yet subscribed to Cold Case Hour, please do so now and hit the like button below. We bring you these verified, documented cases because every victim and every survivor, regardless of age, regardless of the circumstances of their case, deserves to have their story told with accuracy and respect. Case 4 is coming up next. Case 4, Rosemary Gile. Burlington, Vermont, Chittenden County Superior Court. July 22, 2014. Burlington is Vermont's largest city and the county seat of Chittenden County, situated on the eastern shore of Lake Champlain with the Green Mountains rising dramatically to the east and the broad expanse of the lake stretching westward toward New York State. It is a city of universities, medical centers, arts institutions, and a population that is, by Vermont standards, remarkably cosmopolitan and diverse. The University of Vermont, founded in 1791, anchors the educational and economic life of the city. Church Street Marketplace, the pedestrian downtown corridor, serves as the commercial and social heart of a community that attracts students, tourists, young professionals, and families from across the region. But Burlington is also a city with real and persistent social challenges. Issues of housing affordability, substance use disorder, mental health access, and economic inequality that affect working families and low-income residents in ways that are less visible from the outside, but deeply consequential for those who live them. The same city that projects an image of New England charm and progressive civic culture also maintains a network of social services, emergency shelters, substance treatment programs, and child protective services offices that exist because the need for them is real and sustained. The University of Vermont Medical Center anchors the city's healthcare landscape. As a Level 1 trauma center and academic medical institution, it serves as the primary regional hospital for northern Vermont and receives patients from across the Green Mountain State and beyond. Its pediatric care program is one of the most comprehensive in northern New England, staffed by specialists in every aspect of child health and illness. The hospital's emergency department receives some of the most critical cases in the region, and the staff there are trained to document meticulously the circumstances and physical findings associated with every case that comes through their doors. It was within the Burlington area that, on July 22, 2014, emergency services received a call that would result in the death of an infant and the subsequent criminal prosecution of a caregiver in the Chittenden County Superior Court. On that date, emergency services were called to respond to a report that a 4-week-old infant had stopped breathing. The call came in as the kind of medical emergency that dispatchers and first responders treat with absolute urgency. Every second matters when a newborn infant stops breathing. The physiological reserves of a child that young are minimal, and the window of time within which intervention can make a meaningful difference is narrow. First responders activated immediately upon receiving the call and arrived at the location as quickly as possible. When they arrived, the 4-week-old infant was in critical condition. Emergency personnel began life-saving procedures and prepared the child for immediate transport to medical facilities equipped to handle a critically ill newborn. The infant was transported to receive emergency medical care. Despite the efforts of the medical professionals who worked to stabilize and treat the child, the baby did not survive. The 4-week-old infant died. To understand the significance of the age of this child, 4 weeks old, it is necessary to appreciate just how completely dependent a newborn infant is on the adults in their immediate environment. At 4 weeks of age, a human infant cannot regulate their own body temperature without external assistance. They cannot seek food. They can only cry and hope that cry is heard and responded to. They cannot move to safety. They cannot communicate distress in any way other than through the most basic and inarticulate of signals. They require feeding every 2 to 3 hours around the clock. They require constant monitoring, consistent physical contact, and the sustained, attentive presence of a caregiver who understands and responds to their needs. The survival of a 4-week-old infant is entirely contingent on the quality and consistency of the care provided by the adults responsible for them. The death of a 4-week-old child under any circumstances is a tragedy of profound magnitude, one that carries enormous emotional weight for the family, for the medical professionals who work to save the child, and for the community that processes the news of such a loss. The circumstances surrounding this particular death, however, move the case beyond the realm of medical tragedy and into the realm of criminal investigation, because the findings of the medical examination and the subsequent investigation of law enforcement pointed to a cause of death that could not be explained by natural illness or unavoidable circumstance. Medical professionals documented their findings carefully. Investigators examined the circumstances of the infant's death with the thoroughness that Vermont law and professional standards require in all cases of infant fatality. What that examination and investigation determined was that the death involved criminal neglect, a failure in the duty of care owed to the infant that was so profound, so consequential, and so far below the standard of care that any reasonable person in the same caregiving role would exercise, that it rose to the level of criminal culpability under Vermont law. Rosemary Gile was the caregiver responsible for the 4-week-old infant at the time of the child's death. She was charged with involuntary manslaughter and cruelty to a child in connection with the infant's death. These charges reflect a legal determination by the Chittenden County State's Attorney's Office that the death resulted from a criminal failure in the duty of care owed to the infant. Not an accident in the true sense. Not an unavoidable tragedy that no level of care could have prevented. A failure, a serious, consequential, criminal failure, to provide the attentive and protective care that a 4-week-old infant requires for their survival. The case proceeded through the Chittenden County Superior Court. The prosecution's case rested on the medical findings regarding the cause of the infant's death, the investigative record assembled by law enforcement, and the determination by investigators and medical professionals that criminal neglect had contributed directly to the loss of this child. The proceedings were handled with the gravity and care that the death of a newborn demands, and the court record preserves the full account of what was alleged, what was presented in evidence, and what the Vermont court system determined in response. The case of Rosemary Gile is, in many ways, a case about the most fundamental and absolute obligation that any human being can bear. The obligation to care for a newborn child who has been placed in your custody is not a qualified obligation. It is not an obligation that can be discharged partially or intermittently. A 4-week-old infant requires round-the-clock, attentive, consistent, competent care, and the failure to provide that care at a criminal level of inadequacy has one likely and irreversible consequence. It costs the child their life. The Chittenden County Superior Court processed this case as part of its responsibility to the people of Burlington and the broader county community. The legal record of what happened to that 4-week-old infant on July 22, 2014 is preserved in the court records of the county. That record ensures that the circumstances of the infant's death are documented, that the criminal proceedings brought in response to those circumstances are part of the permanent judicial history of Chittenden County, and that the child whose life ended at 4 weeks is not simply a statistical entry in a medical database, but a named individual whose death was the subject of serious and sustained attention from Vermont's legal system. The infant was 4 weeks old, barely a month into a life that should have stretched across decades, should have included school and friendships and seasons, and all the ordinary and extraordinary experiences that constitute a human life. That life was cut short. The Vermont court system worked to ensure that the criminal record reflected what had happened, and that accountability was pursued through the legal processes of Chittenden County Superior Court. Please like this video and subscribe to Cold Case Hour to stay informed about these important and verified cases. Your engagement helps us continue this work. We move now to Case 5. Case 5, Jeanne Sevigny. Westford, Vermont, Chittenden County Superior Court. June 20, 2006. Westford is a small rural town in Chittenden County, Vermont, located a short distance northeast of Burlington in the gently rolling agricultural landscape that lies between the Winooski River Valley and the foothills of the Green Mountains. It is a quiet town of just over 2,000 residents, the kind of Vermont community where farmhouses sit back from the road behind old stone walls, where the fields change color with the seasons in ways that have not fundamentally altered for generations, and where the pace of life is measured and deliberate. The town has no downtown to speak of, no traffic lights, no commercial strip. It is a place of fields and forests and the kind of deep quiet that city dwellers sometimes seek out and long-term residents take for granted. In this quiet, unhurried community, in the early summer of 2006, an investigation began that would expose a crime of startling violence and deliberate concealment. A crime that began with the killing of an elderly woman and continued through the systematic destruction of evidence and the involvement of a family member in the disposal of human remains. The victim was Mary Wilcox, 78 years old. Mary Wilcox was, by the facts of the case as documented in court records and investigative findings, a woman who had reached the final chapter of a long life in the state of Vermont. At 78 years old, she was elderly, potentially frail in ways consistent with her age, and living in circumstances that placed her in close and regular proximity to her daughter, Jeanne Sevigny. Whatever the precise nature of the living arrangement and the relationship between mother and daughter in the years and months leading up to June of 2006, the outcome of that relationship was documented in the findings of Vermont law enforcement and in the charges brought before the Chittenden County Superior Court. On or around June 20th, 2006, Mary Wilcox was killed. The investigation conducted by Vermont law enforcement determined that Jeanne Sevigny was responsible for her mother's death. The charge brought against Sevigny was second-degree murder, a charge that carries with it the legal finding that the killing was intentional, that it was not the result of negligence or recklessness, and that it was not accidental. A daughter had intentionally killed her 78-year-old mother. But the killing of Mary Wilcox was not the only element of this case that made it so profoundly disturbing to the investigators, prosecutors, and community members who encountered it. What happened in the immediate aftermath of Mary Wilcox's death revealed a level of deliberate calculation and evidence destruction that compounded the gravity of the original crime in ways that investigators and prosecutors found particularly disturbing. Following the death of Mary Wilcox, Jeanne Sevigny did not call emergency services. She did not seek help. She did not notify family members through the ordinary channels of grief and loss. Instead, investigators determined she moved to conceal what had happened. Mary Wilcox's body was burned in a fire pit in the backyard of the property. The burning of a human body for the purpose of concealing evidence of a crime is among the most serious and deliberate acts of evidence destruction that law enforcement encounters in the course of criminal investigations. It requires sustained effort. It requires time and deliberate action. It is not an impulsive response to a moment of crisis. It is a calculated decision to prevent the discovery of a crime and to eliminate the physical evidence that would otherwise tell the story of what had occurred. The investigation into what happened to Mary Wilcox also revealed that Jeanne Sevigny had not acted entirely alone in the aftermath of the killing. Evidence gathered by investigators indicated that Sevigny had asked her own son to assist in the disposal of his grandmother's remains. A son was enlisted by his mother to help deal with the physical remnants of his grandmother's life, a grandmother who had been killed by that son's own mother. The layers of family trauma embedded in this element of the case are difficult to fully process. A young man, whatever his awareness of the full circumstances, was drawn into the criminal aftermath of a murder committed by his own parent against his own grandparent. The Vermont State Police and the Chittenden County State's Attorney's Office conducted a meticulous investigation into the circumstances of Mary Wilcox's death, the subsequent burning of her remains, and the efforts made to prevent law enforcement from discovering what had happened. That investigation required the kind of patient, thorough forensic and investigative work that cases involving evidence destruction demand. The assembling of a picture from fragments and traces, the reconstruction of a timeline from the accounts of witnesses and the physical evidence that survived destruction, and the building of a legal case that could withstand the scrutiny of the Chittenden County Superior Court. Jeanne Sevigny was charged with second-degree murder in the killing of Mary Wilcox, as well as with charges related to the concealment and destruction of the body and the evidence tampering that followed. The prosecution built its case on the forensic findings, the investigative record, and the testimony and evidence that documented the full scope of the alleged criminal conduct, from the killing itself through the burning of the body in the backyard fire pit and the involvement of a family member in the disposal of remains. The case proceeded through the Chittenden County Superior Court in Burlington, the same court that handled other serious felony cases in Chittenden County during that period. It drew significant attention both locally and more broadly in Vermont, generating news coverage that reflected the community's profound disturbance at the nature of the allegations. The murder of an elderly mother by her own daughter, followed by the burning of her body to conceal the crime, is a case that challenges the most fundamental assumptions about the safety of family relationships and the protection owed to elderly and vulnerable individuals by those closest to them. The case raises broader questions about the circumstances of elderly individuals who are dependent on family members for their daily lives. Questions about vulnerability, about oversight, and about the systems in place to monitor the welfare of elderly people in situations where their dependency may place them at risk. These are questions that have become increasingly urgent as Vermont, like most of the developed world, faces the demographic reality of an aging population. The case of Jeanne Sevigny and the death of Mary Wilcox stands as a sobering data point in that broader conversation. Mary Wilcox was 78 years old. She had lived a long and full life in Vermont. She had raised a family and seen her grandchildren born. She had navigated decades of change in the state she called home. She deserved to spend her remaining years in safety, in comfort, in the company of people who cared for her and treated her with the dignity that her long life warranted. Instead, her life ended at the hands of her own daughter, and her remains were destroyed in a deliberate effort to ensure that what had been done to her would never be discovered. The Chittenden County Superior Court ensured that the record of what happened to Mary Wilcox on June 20, 2006 was formally documented and prosecuted. Her case is part of the permanent legal record of Vermont. Her name deserves to be spoken with respect, with recognition of the life she lived before that June morning, and with the acknowledgement that the Vermont legal system worked to ensure that what was done to her did not remain hidden. Please take a moment to like this video and subscribe to Cold Case Hour. We will continue with Case 6 right after this. Case 6, Robin O'Neill. Townsend, Vermont, Windham County Superior Court. November 18, 2014. Townsend is a small town in Windham County in southeastern Vermont, situated in the West River Valley in a landscape of forested hills, covered bridges, and the quiet pastoral beauty that defines this corner of the Green Mountain State. Windham County occupies the southernmost region of Vermont, bordering Massachusetts to the south and New Hampshire to the east, and its communities carry the particular character of a part of Vermont that has long been shaped by both its rural isolation and its proximity to the cultural and economic influence of southern New England. Townsend itself is a community of fewer than 1,200 residents, a town where a single event of serious consequence touches everyone, where the ripple effects of tragedy spread quickly through the fabric of daily life, and where the arrival of law enforcement at a residence on a quiet November evening becomes a moment that the community does not easily set aside. It was in Townsend, on the evening of November 18, 2014, that Vermont State Police responded to a call that would set in motion one of the most serious criminal investigations in Windham County's recent history, an investigation that would ultimately result in the most serious murder conviction available under Vermont law, a unanimous jury verdict, and a sentence that closed the door on any possibility of the perpetrator ever returning to the community she had devastated. The events of that November evening centered on a relationship that had reached its breaking point. Robin O'Neill was 62 years old in the autumn of 2014. She had been engaged to Stephen Lott, 60 years old, a man who lived on Abbey Road in Townsend. On the evening of November 18, 2014, Stephen Lott ended the engagement. It was a decision that any person in a relationship has the absolute right to make. The decision to step away from a commitment that was no longer something they wished to continue. It was a decision that, in the overwhelming majority of human relationships, leads to grief, to difficulty, to the painful process of separation and adjustment that the end of a significant relationship always involves. What followed in the O'Neill case was not grief and separation. What followed was an act of violence that ended 2 lives and shattered a family and a community in ways that the Windham County courts and the Vermont justice system would spend years addressing. Stephen Lott's son, James Lott, was 28 years old on the night of November 18, 2014. He was present at his father's residence on Abbey Road in Townsend that evening. Whatever the precise sequence of events that unfolded inside that home after Stephen Lott informed Robin O'Neill that the engagement was over, what investigators documented in the aftermath was devastating in its clarity and its finality. Both Stephen Lott and his son James Lott lost their lives that night. They were found at the residence on Abbey Road. Both had sustained injuries that investigators determined were the result of gunshot wounds inflicted by Robin O'Neill. The call that brought Vermont State Police to the scene that November evening came not from inside the residence, but from a friend of O'Neill's who had been notified of what had occurred. That call came in at approximately 8:58 in the evening, and Vermont State Police responded rapidly to the Abbey Road address in Townsend. When they arrived, they found a scene that required immediate processing and investigation, and they found Robin O'Neill herself still present at the location. What investigators encountered when they made contact with O'Neill at the scene was significant not only in the immediate evidentiary sense, but but in the context of everything that would follow in the legal proceedings. O'Neill was found to be highly intoxicated, and in that state, before her formal arrest, and in the period immediately following it, she made multiple statements to law enforcement that investigators documented carefully and that prosecutors would later characterize as self-incriminating. The statements made by O'Neill in those early hours after Vermont State Police arrived at the Townsend residence would become a central element of the criminal case that the Windham County State's Attorney's Office built against her in the months that followed. The investigation was conducted by the Vermont State Police with the thoroughness and precision that a double fatality case demands. Every piece of physical evidence was gathered and preserved. Every witness was interviewed. The timeline of the evening was reconstructed in detail. The forensic record assembled by investigators in the hours, days, and weeks following November 18, 2014, was comprehensive and the basis for charges of extraordinary seriousness. Robin O'Neill was charged with aggravated murder, the most serious category of murder charge available under Vermont law. Aggravated murder is a distinct and elevated charge under the Vermont Criminal Code, triggered in circumstances where the facts of the case meet specific criteria that elevate the offense beyond the already serious charge of first-degree murder. One of those triggering circumstances is precisely the situation presented by the events of November 18, 2014, the taking of 2 lives in the same criminal act. Vermont law treats this circumstance with the utmost seriousness, and the penalty available upon conviction reflects that seriousness in the most absolute terms. Under Vermont law, a conviction for aggravated murder carries an automatic sentence of life in prison without the possibility of parole. There is no judicial discretion in the application of this penalty upon conviction. It is the most severe sentence available in Vermont's criminal code, reflecting the legislature's determination that certain acts of violence are so serious, so destructive of human life, and so threatening to the fabric of the community that the only appropriate response is permanent incarceration. The case proceeded to trial before the Windham County Superior Court. The prosecution presented the physical evidence gathered at the scene, the forensic findings of investigators, the statements O'Neill had made to law enforcement in the immediate aftermath of the events of November 18, and the expert testimony that supported the state's case. The defense challenged the admissibility of some of O'Neill's statements, arguing that the circumstances under which they were made compromised their reliability or their admissibility under Vermont's evidentiary standards. These legal challenges were addressed by the court through the formal processes of pretrial motions and rulings, and the case ultimately proceeded to a full jury trial. On June 28, 2017, the jury in the Windham County Superior Court returned its verdict. Robin O'Neill was convicted of aggravated murder on both counts, the taking of the lives of Stephen Lott and Jamie's Lott on the evening of November 18, 2014. The verdict was unanimous. 12 members of the Windham County community, having heard all of the evidence presented by both sides, having deliberated carefully and conscientiously, and having applied the legal standards provided by the court, concluded beyond a reasonable doubt that Robin O'Neill was guilty of the most serious criminal charge that Vermont law provides for. The sentence that followed the conviction was, as Vermont law requires upon an aggravated murder conviction, life in prison without the possibility of parole. Robin O'Neill would never return to Townsend or to any other Vermont community. The sentence was imposed and the case was formally concluded at the trial court level. But the legal proceedings did not end with the conviction and sentencing at the Windham County Superior Court. Robin O'Neill filed an appeal, challenging both the sufficiency of the evidence presented against her and the trial court's rulings on the admissibility of the statements she had made to law enforcement in the immediate aftermath of the events of November 18. These are the 2 most common grounds for appeal in serious criminal cases: challenges to the weight and sufficiency of the evidence, and challenges to the legal rulings that governed what the jury was permitted to hear and consider. The Vermont Supreme Court, the highest court in Vermont's judicial system, and the final arbiter of Vermont criminal law, took up the appeal and considered O'Neill's arguments with the thoroughness that the court brings to all cases involving the most serious criminal convictions under state law. The justices reviewed the trial record, considered the legal arguments advanced by O'Neill's appellate counsel, and evaluated the rulings and findings of the Windham County Superior Court against the standards of Vermont criminal law and constitutional due process. On March 29, 2019, the Vermont Supreme Court issued its decision. The court unanimously denied Robin O'Neill's appeal. Every justice who considered the case agreed that the conviction was supported by sufficient evidence, that the trial court's evidentiary rulings were proper, and that the proceedings in the Windham County Superior Court had been conducted in accordance with Vermont law and constitutional requirements. The conviction stood. The sentence of life without the possibility of parole was affirmed. The legal process that had begun on the night of November 18, 2014 reached its final and permanent conclusion. The Vermont Supreme Court's unanimous decision in this case carries significance that extends beyond the immediate parties and the Townsend community. It confirmed that the evidentiary record assembled by Vermont State Police investigators was legally sufficient to support the most serious murder conviction available under state law. It confirmed that the statements O'Neill made to law enforcement in the immediate aftermath of the events at the Abbey Road residence were properly admitted and considered by the jury. And it confirmed that the automatic life without parole sentence imposed upon conviction for aggravated murder is constitutionally valid and appropriately applied in circumstances like those of November 18, 2014. The case was confirmed across the Brattleboro Reformer, the Rutland Herald, Fox News, the Berkshire Eagle, the published opinion of the Vermont Supreme Court, and Court Listener. It is a case that is fully documented in the legal record of Vermont at both the trial court and Supreme Court levels, and it stands as one of the most serious and consequential criminal prosecutions in Windham County's history. Stephen Lott was 60 years old. He had made a decision about his own life, the entirely ordinary and entirely human decision to end a relationship that he no longer wished to continue. That decision, which should have been the beginning of a new chapter in his life, instead cost him everything. James Lott was 28 years old, a young man at the beginning of his adult life, with everything ahead of him, present at his father's home on a November evening in Vermont, and caught in the devastating consequences of another person's choice to respond to loss with violence. Two people who deserved to go home that night did not. Two families were fractured in ways that no court proceeding, however thorough or however just, can repair. The Townsend community, small and tight-knit as Vermont communities are, carried the weight of what happened on Abbey Road with it through the years of legal proceedings that followed and beyond. The Vermont justice system, through the investigations of the Vermont State Police, the prosecution brought by the Windham County State's Attorney's Office, the proceedings of the Windham County Superior Court, and the unanimous affirmation of the Vermont Supreme Court, responded to the events of November 18, 2014 with the full force of the law. Robin O'Neill will spend the remainder of her life in a Vermont correctional facility. The communities she left behind continue to heal. If you or someone you know is experiencing a relationship crisis or needs support, the National Domestic Violence Hotline is available 24 hours a day, 7 days a week, at 1-800-799-SAFE. Help is always available, and no one has to face a difficult situation alone. Stephen Lott and James Lott deserve to live. Their names are preserved in the legal record of Vermont, in the published opinion of the Vermont Supreme Court, and in the memory of everyone who loved them. The justice system did its work. Their story is part of the permanent record of Windham County, and it will not be forgotten. Don't forget to hit the like button and subscribe to Cold Case Hour. Your support keeps these important and verified stories reaching the people who need to hear them. Case 7 is coming up next. Case 7, Stacy Vaillancourt. Rutland, Vermont, Rutland County Superior Court. January 24, 2019. The Rutland County Superior Court had already seen serious criminal cases involving the welfare of children in the years leading up to 2019. But the case that came before that court in connection with the events of January 24, 2019 would become one of the most closely watched and most consequential child welfare prosecutions in Vermont's recent judicial history. It was a case that would travel from the Rutland County Superior Court all the way to the Vermont Supreme Court before its legal conclusions were firmly and finally established. A progression through the Vermont judicial system that confirmed the gravity and significance of the underlying proceedings. Rutland is a city that takes its community seriously. It is a city with active civic organizations, a strong network of social services, and a population that is engaged with the institutions and systems that govern community life. The news that a 6-month-old infant had died in a local daycare setting landed in this community not as an abstract news event, but as a personal and immediate shock. A shock felt by every parent in the region who had ever placed a child in someone else's care and trusted that the person receiving that trust was worthy of it. Harper Rose Breyer was 6 months old at the time of her death. She was an infant girl who had been entrusted by her parents to the care of Stacy Vaillancourt, who operated a daycare in Rutland. The specific circumstances of Harper's care arrangement, the days she attended, the hours her parents relied on Vaillancourt's facility, the nature of the caregiving relationship, are part of the documented record of this case. What matters in the broadest sense is that Harper's parents had placed their daughter in a professional caregiving environment, had paid for that care, and had extended to Stacy Vaillancourt the most profound form of trust that parents can extend to another adult, the trust of their child's safety and well-being. That trust was not honored. On January 24, 2019, Harper Rose Breyer died while in the care of Stacy Vaillancourt. She was 6 months old. The medical examination that followed Harper's death was thorough and produced findings that were both medically specific and profoundly alarming. Toxicology testing, the systematic analysis of the chemical contents of a deceased person's biological samples, revealed the presence of diphenhydramine in Harper's system. The levels at which diphenhydramine was found were determined by medical experts to be dangerous for an infant of Harper's age and size. Diphenhydramine is an antihistamine compound found in a wide range of over-the-counter medications. In adults, it is most commonly used as an allergy medication or a sleep aid. In very young children, including infants, the administration of diphenhydramine is generally contraindicated, meaning that medical professionals advise against its use in infants, particularly without direct medical supervision. The compound has physiological effects in infants that are substantially different from and more dangerous than its effects in adults, and its administration to a 6-month-old infant without parental consent, without medical authorization, and outside the context of any legitimate therapeutic purpose is, under Vermont law, a serious criminal act. The investigation that followed Harper's death was conducted by the Rutland Police Department working in close coordination with the Vermont State Police. Investigators examined every aspect of the circumstances surrounding Harper's death with the thoroughness that infant fatality cases demand and Vermont law requires. The toxicology findings were the centerpiece of the evidentiary case, but the investigation extended well beyond the laboratory results to encompass the full context of what had happened at Vaillancourt's daycare on January 24, 2019. The investigation produced sufficient evidence for the Rutland County State's Attorney's Office to bring criminal charges against Stacy Vaillancourt. She was charged with involuntary manslaughter and child cruelty in connection with the death of Harper Rose Breyer. Involuntary manslaughter, as defined under Vermont law, involves a killing that results from conduct that is criminally negligent or reckless to a degree that far exceeds ordinary carelessness. Conduct that a reasonable person would recognize as creating a substantial and unjustifiable risk of death or serious harm. The additional charge of child cruelty reflects the particular vulnerability of Harper and the nature of the conduct that investigators determined had led to her death. The case proceeded through the Rutland County Superior Court with the seriousness and public attention that the death of a 6-month-old infant in a professional childcare setting demands. The prosecution presented the toxicology evidence, the expert medical testimony regarding the physiological effects of diphenhydramine on an infant and the manner in which it contributed to Harper's death, and the investigative record assembled by law enforcement. Vermont media outlets, including WCX, VT Digger, and the Associated Press, covered the proceedings extensively, ensuring that the case remained in the public consciousness throughout the judicial process. Stacy Vaillancourt was convicted. The Rutland County Superior Court found that the evidence presented by the prosecution was sufficient to establish her guilt on the charges brought against her. She was sentenced to a term of 3 to 10 years in the Vermont correctional system. The sentence reflected the court's assessment of the severity of the criminal conduct and the devastating and irreversible consequences that conduct had produced for Harper Rose Breyer and for her family. The legal proceedings did not conclude with the conviction and sentencing at the trial court level. Vaillancourt's case continued through the Vermont appellate system. as defendants in serious criminal cases have the right under Vermont law and the United States Constitution to seek review of their convictions at a higher court level. The case ultimately reached the Vermont Supreme Court, the highest court in the state's judicial system, which conducted its own thorough review of the legal issues raised by the appeal. In May of 2025, the Vermont Supreme Court issued its ruling in the case, upholding the conviction of Stacy Vaillancourt. The Supreme Court's affirmation of the lower court's findings and the validity of the prosecution's evidence and legal arguments cemented the permanent legal record of this case and concluded the judicial process that had begun with Harper's death on January 24, 2019. The Vermont Supreme Court's ruling carries significance that extends beyond the parties in this particular case. By upholding the conviction, the court reinforced the legal standards governing the duty of care owed by child care providers to the children in their custody, and it confirmed that the criminal penalties available under Vermont law are applicable to child care providers whose conduct meets the threshold of criminal negligence or recklessness in ways that cost a child their life. The ruling sends a clear and unambiguous message to every licensed child care provider in Vermont about the legal consequences that can follow a criminal breach of the duty of care. Harper Rose Breyer was 6 months old. She was left in the care of someone her parents trusted completely and without reservation. She was given a substance that had no legitimate place in her care. She did not come home from daycare on January 24, 2019. Her parents endured the most unimaginable loss that parents can face, and then they endured the additional difficulty of watching a criminal case proceed through the courts over the years that followed. Years during which the absence of their daughter was a constant presence in everything they did. Harper's name is in the legal record of Vermont at 2 levels, in the trial court record of Rutland County Superior Court and in the published opinion of the Vermont Supreme Court. She is named. She is documented. The Vermont justice system, from the first responders who responded on January 24 through the Supreme Court justices who reviewed the case more than 6 years later, took her death seriously and held accountable the person their proceedings found responsible. Harper Rose Breyer mattered. She still matters. Please like this video and subscribe to Cold Case Hour if you have not already. These cases deserve to be remembered, and your support helps make that possible. Case 8 is coming up next. Case 8, Carmen Guttilla. Highgate, Vermont, Franklin County Superior Court. July 7, 2018. Highgate is a small town in Franklin County, Vermont, located in the northwestern corner of the state in the flat, open landscape that characterizes the region between the Missisquoi River and the Canadian border. It is a rural community of approximately 3,500 residents, a place of farmland, forest, and modest residential neighborhoods where the rhythms of daily life move slowly, and where the nearest significant urban center is St. Albans, the Franklin County seat, located a short drive to the south along Route 7. Franklin County as a whole is one of Vermont's more rural and somewhat isolated counties. Its proximity to the Canadian border has historically shaped its economy and culture in particular ways, and its population reflects the practical realities of life in a border community. The tight-knit nature of rural Vermont, combined with the particular dynamics of a region where geography creates both connection and isolation. The Franklin County Superior Court in St. Albans handles the full range of criminal proceedings for the county, and its case history reflects the realities of life in this part of Vermont, including the serious and violent criminal cases that arise in any community regardless of its size or its rural character. On July 7, 2018, an event took place in Highgate that drew the attention of the Vermont State Police and set in motion a criminal investigation that would ultimately result in felony charges before the Franklin County Superior Court. The victim was a man named Troy Ford. Troy Ford was killed, and investigators determined through the course of their investigation that his death was a homicide. The investigation that followed was conducted by the Vermont State Police's Major Crime Unit, working in coordination with the Franklin County State's Attorney's Office. These two bodies, the investigative arm and the prosecutorial arm of Vermont's criminal justice system, worked together to piece together the events surrounding Troy Ford's death, the circumstances that had led to it, and the individuals whose conduct had contributed to the criminal situation that followed. What the investigation uncovered was not only the facts of Troy Ford's death, but the deliberate and calculated actions that had been taken in its aftermath to conceal what had happened and to prevent law enforcement from assembling the evidence they needed to pursue justice. Those actions, the concealment of the body, the tampering with evidence, the active effort to prevent the truth of Troy Ford's death from coming to light, formed the core of the criminal case against Carmen Guttilla. Investigators determined that following Troy Ford's killing, Guttilla had participated in the concealment of his body. Troy Ford's remains were hidden in a wooded area, concealed in the landscape of rural Franklin County in an effort to prevent their discovery. Beyond the physical concealment of the body, investigators determined that Guttilla had also engaged in evidence tampering, taking actions designed to destroy, alter, or otherwise compromise the physical evidence that would be necessary for law enforcement to investigate the crime and build a prosecutable case. Carmen Guttilla was charged with being an accessory to murder after the fact, with concealing a dead body, and with evidence tampering. Each of these charges carries its own legal definition and its own set of elements that the prosecution was required to prove beyond a reasonable doubt before the Franklin County Superior Court. Accessory to murder after the fact under Vermont law is a serious felony charge that reflects a determination that the person charged had specific knowledge that a murder had been committed, provided active assistance to the person who committed the murder in their efforts to evade justice and avoid detection, and did so with the full awareness of what they were doing and why. The word after the fact is significant in legal terms. It distinguishes the conduct from that of someone who participated in planning or committing the murder itself, but it does not diminish the seriousness of the charge or the consequences that conviction carries. The charge of concealing a dead body reflects a distinct and specific criminal act, the physical act of hiding, moving, or otherwise concealing human remains for the purpose of preventing their discovery by law enforcement. This is not a metaphorical charge. It involves the actual, physical concealment of a human being's body in a wooded area of Franklin County, Vermont, with the intent to prevent that body from being found and to prevent the investigation of the crime that caused the person's death from proceeding. Evidence tampering, the third charge, reflects the additional steps that investigators determined Guttilla took beyond the concealment of the body itself, steps intended to alter, destroy, or compromise the physical evidence that law enforcement would need to investigate and prosecute the case. Evidence tampering is a direct assault on the integrity of the criminal justice process, and Vermont law treats it as a serious criminal offense for exactly that reason. The case proceeded through the Franklin County Superior Court, where the prosecution presented the investigative findings of the Vermont State Police, the forensic evidence assembled during the course of the investigation, and the testimony of witnesses whose accounts supported the state's theory of the case. The proceedings were followed closely by local media and by the Highgate community, which had been shaken by the discovery of what had happened to Troy Ford and by the revelation of the efforts that had been made to conceal his fate. Troy Ford's family endured the compound trauma of losing a family member to violence, and then discovering that people with knowledge of his death had taken active and sustained steps to hide what had happened to him, to prevent him from being found, to prevent the truth of his death from coming to light, and to protect those responsible from the consequences of the crime. This is a harm that extends beyond the original killing. The concealment of a murder victim is a secondary violation of both the victim and of the people who love them. It denies the family the knowledge of what happened. It delays justice. It prolongs uncertainty and grief in ways that the family may carry for years. The Franklin County Superior Court and the Vermont legal system worked to ensure that the full scope of the criminal conduct surrounding Troy Ford's death was brought before a court of law and adjudicated properly. The charges against Carmen Guttilla were serious. The evidence assembled by investigators was presented to the court through the formal processes of the Vermont judicial system, and the proceedings ensured that the record of what happened in Highgate on and after July 7, 2018 was preserved in the permanent legal record of Franklin County. Troy Ford deserved to be found. He deserved for the truth of what happened to him to be known. He deserved the justice that the Vermont court system worked to deliver through the proceedings in Franklin County Superior Court. His family deserved answers, and the legal system worked to provide them. Please take a moment to like this video and subscribe to Cold Case Hour. We are now moving into the final two cases of Vermont Dark Secrets, and these are cases that sent shockwaves through Vermont and beyond. Case 9 is next. Case 9, Patricia Prue. St. Johnsbury, Vermont, Caledonia County Superior Court. March 2012. St. Johnsbury is the largest town in Caledonia County and the undisputed center of Vermont's Northeast Kingdom, a region that occupies the northeastern corner of the state and carries an identity that is distinct even within the context of a state that prizes its independence and distinctiveness. The Northeast Kingdom is Vermont distilled, more rural, more remote, more self-reliant, and in many ways more traditionally Vermont than the more populous counties to the south and west. St. Johnsbury sits at the confluence of the Passumpsic, Moose, and Sleepers rivers, and its Victorian-era downtown reflects the ambitions of a community that in the 19th century saw itself as a major regional center and invested accordingly in civic architecture and cultural institutions. The Fairbanks Museum and Planetarium, founded in 1891, stands on Main Street as a symbol of St. Johnsbury's historical commitment to science and learning. The St. Johnsbury Athenaeum, a public library and art gallery that dates to 1871, houses a collection of 19th-century American paintings that would be remarkable in any city of any size. These institutions speak to the aspirations of a community that has always understood itself as more than the sum of its modest population, a town with a civic identity that exceeds its geographic and demographic limitations. It was in this community, in the late winter and early spring of 2012, that events unfolded that would draw national media attention to St. Johnsbury and to Vermont's Northeast Kingdom in a way that its residents had not previously experienced. A beloved teacher had vanished. A 2-year-old child had been found alone in an abandoned car in the Vermont night. And investigators would ultimately piece together a story of premeditated violence, obsessive jealousy, and a staged emergency call that had lured an innocent woman to her death. The victim was Melissa Jenkins. She was 33 years old in the spring of 2012, a schoolteacher whose presence in the St. Johnsbury area community had made her a well-known and genuinely beloved figure. Teaching, in a community like St. Johnsbury, is not simply a profession, it is a relationship. A teacher in a small northeastern kingdom town is a person who knows her students personally, who is known to their families, who participates in the life of the community in ways that extend far beyond the classroom. The teachers in such communities are not interchangeable. They are individuals whose presence in the educational and civic life of the town is felt and valued in a personal way that large urban school systems rarely allow for. Melissa Jenkins was that kind of teacher. By all accounts from those who knew her, her colleagues, the families of her students, her friends and neighbors, she was a person whose warmth, energy, and genuine dedication to the young people in her care made her a central figure in the St. Johnsbury educational community. She was also a mother. Her 2-year-old son was the center of her personal life, and the two of them were, by the accounts of those who knew them, a tight and loving family unit. In March of 2012, Melissa Jenkins received a phone call. The call came from a number associated with Alan Prue, a man known to Jenkins. The person who made the call, investigators would later work to establish the precise circumstances, conveyed to Jenkins that a vehicle had broken down and that assistance was needed. It was the kind of call that most people, in most circumstances, would respond to as a matter of ordinary human decency. Melissa Jenkins was, by all accounts, exactly the kind of person who would respond to such a call. She agreed to help. She gathered her things, placed her 2-year-old son in his car seat in the back of her vehicle, and drove out into the Vermont night to assist someone she believed was in genuine need. She did not come home. When Melissa Jenkins failed to return from what should have been a brief errand of assistance, alarm bells began to ring for the people who loved her and for the community that had come to depend on her presence. A search was initiated. The urgency of that search was compounded by the knowledge that Jenkins had taken her young son with her when she left. The safety of both mother and child was unknown. And in the tight-knit community of St. Johnsbury and the broader Northeast Kingdom, the disappearance of a beloved teacher and her toddler created the kind of collective anxiety that only the complete absence of information can produce. What investigators found in the course of the search was a scene that crystallized the nature of the crime that had been committed and the deliberate cruelty that had characterized its execution. Melissa Jenkins' car was found abandoned. Her 2-year-old son was still strapped into his car seat in the back of the vehicle, alone, in the dark, waiting with the incomprehending patience of a toddler for a mother who would never come back for him. The image of that 2-year-old boy, alone in an abandoned car in the Vermont night, became one of the most haunting and emotionally resonant images associated with this case in the public consciousness of Vermont and of the national media that covered the story. It spoke with devastating clarity to the complete disregard for human life. Not only the life of Melissa Jenkins herself, but the life of the toddler who had been present when his mother was taken, that had characterized the planning and execution of this crime. Whoever had done this had known that the child was there, had known that taking Jenkins would leave a toddler alone in an abandoned vehicle, had made the choice to proceed anyway. The investigation that followed was among the most extensive and resource-intensive criminal investigations in Vermont's recent history. The Vermont State Police Major Crime Unit deployed significant investigative resources to the case, working around the clock to piece together what had happened, to identify the individuals responsible, and to locate Melissa Jenkins. The investigation required the coordination of multiple agencies, the canvassing of witnesses across a wide geographic area, and the painstaking analysis of the communications and movements of the people identified as persons of interest. The investigation led investigators to Alan Prue and his wife, Patricia Prue. The Prues became the central focus of the investigation, and both were ultimately arrested and charged in connection with Melissa Jenkins' disappearance and death. Investigators determined that Melissa Jenkins had been attacked after responding to the staged breakdown call, that she had been strangled and beaten, and that her body had been concealed. The investigative findings regarding Patricia Prue's specific role in the crime produced evidence that prosecutors would present before the Caledonia County Superior Court as the basis for the most serious criminal charges available under Vermont law. Investigators and prosecutors assembled a case that pointed to Patricia Prue as an active participant in the planning and execution of the crime against Melissa Jenkins, not merely a passive bystander or a person who had knowledge of the crime after the fact, but someone whose involvement was integral to what had occurred. The prosecution's theory of the case, as developed through the investigative record and presented in the Caledonia County Superior Court proceedings, pointed to obsessive jealousy as the primary motivating factor behind Patricia Prue's alleged involvement. Prosecutors argued that Prue had become fixated on Melissa Jenkins in a way that had intensified over time and had ultimately driven her to participate in planning the lure that brought Jenkins to her death. The staged breakdown call, the deceptive pretext, the deliberate creation of a false emergency designed to exploit Jenkins' generous instinct to help. All of these elements, in the prosecution's presentation, reflected planning, deliberation, and a calculated intent to harm. Patricia Prue was charged with first-degree murder and kidnapping in connection with the death of Melissa Jenkins. First-degree murder under Vermont law requires premeditation, the deliberate planning and intentional execution of a killing. The first-degree murder charge reflects the prosecution's determination that what happened to Melissa Jenkins was not an impulsive act, was not a crime of passion in the heat of a moment, but was a planned, deliberate, and premeditated act that had been conceived and executed with full awareness of its consequences. The case attracted national media coverage of a breadth and intensity that Vermont criminal cases rarely receive. ABC News was among the major national outlets that reported extensively on the investigation, the arrests, and the subsequent legal proceedings. The case became the subject of sustained public interest far beyond Vermont's borders, drawing attention to the circumstances of the crime and the community that had been devastated by the loss of Melissa Jenkins. The coverage reflected something that resonated with a broad audience: the terror of a situation in which an ordinary act of human kindness, the simple act of going out to help someone who claimed to need assistance, had been weaponized as the mechanism of a murder. The staged breakdown call is, in its conception, one of the most cynical possible exploitations of human decency, a deliberate construction designed to transform a person's willingness to help others into the instrument of their destruction. The proceedings in Caledonia County Superior Court brought the full weight of the Vermont legal system to bear on the case. The court considered the evidence, heard the arguments of prosecution and defense, and adjudicated the charges against Patricia Prue through the formal processes of Vermont's judicial system. The case required the court to grapple with evidence of planning and premeditation, with the question of Patricia Prue's specific role and intent, and with the legal standards that govern first-degree murder prosecutions in Vermont. Melissa Jenkins was 33 years old. She was a teacher. She was a mother. She was, by the unanimous account of everyone who knew her, a genuinely good human being who went out on a March night in 2012 to help someone she believed was in trouble, and walked into a trap that had been deliberately constructed to end her life. Her 2-year-old son grew up without his mother. The students whose lives she touched, whose educational journeys she was part of, lost a teacher who would have remained a presence in their memories for the rest of their lives. The Northeast Kingdom, and the broader Vermont community, mourned the loss of Melissa Jenkins with an intensity that reflected how widely and how deeply she was known and loved. The legal proceedings in Caledonia County Superior Court were followed by that community with the attention and investment that a case of this magnitude demands, not as entertainment or spectacle, but as the working out of justice for a person who had been taken from them in a way that was both shocking and profoundly unjust. Her name is preserved in the legal record of Vermont, in the news archives of outlets across the country, in the memories of the students she taught, and in the ongoing life of a son who carries her with him every day. Melissa Jenkins mattered. She matters still. And the Vermont court system, through the proceedings in Caledonia County Superior Court, worked to ensure that what happened to her on that March night in 2012 was accounted for in the permanent record of the state she called home. Please like this video and subscribe to Cold Case Hour. We are at our final case, the case that represents the most publicly significant act of violence in Vermont's modern criminal history, a case involving 4 victims, 2 crime scenes, and a chain of events that shook the state to its foundation. Case 10 is next. Case 10, Jody Herring and the murder of Laura Sobel. Bar in Berlin, Vermont, Washington County Superior Court. August 7, 2015. Washington County sits at the geographic and political heart of Vermont, anchored by 2 cities that represent the dual identity of the state as both a governing center and a working community. Montpelier, the state capital, the smallest state capital in the United States by population, sits at the confluence of the Winooski River and the North Branch River, a compact city of government offices, legislative chambers, and the institutional infrastructure that makes Vermont's political life function. A short distance to the east lies Bar, a city of granite and grit, a community whose identity was forged not in the corridors of government, but in the quarries and cutting sheds of the marble and granite industry that brought thousands of immigrant workers to Vermont's Central Hills in the decades surrounding the turn of the 20th century. Bar calls itself the granite capital of the world, and that claim is not idle boasting. The quarries of Bar and the surrounding region have produced some of the finest granite in North America, and the memorials, monuments, and gravestones that bear the Bar mark are found in cemeteries and public spaces across the continent. The city's downtown reflects its working heritage, a compact urban core of brick commercial buildings, neighborhood parks, churches built by the Italian, Scottish, Spanish, and Finnish immigrants who came to work the stone, and a civic culture that values directness, hard work, and community solidarity. It is in this city, a city built by workers, shaped by generations of labor, and proud of its identity as the unglamorous, hard-working counterpart to the governmental elegance of Montpelier just down the road, that the Vermont Department for Children and Families maintains a district office. That office is staffed by social workers, case managers, and support personnel whose daily responsibilities place them in the most difficult and emotionally demanding terrain of the public sector. Their work involves visiting homes in circumstances of family crisis, assessing situations of child neglect or abuse with the full understanding that their assessments carry enormous consequences for the families involved, making recommendations that can determine whether children remain with their parents or are removed for their protection, and navigating the extraordinarily complex intersection of family law, child welfare, substance use disorder, mental health, poverty, and human tragedy that constitutes the daily reality of Child Protective Services work. It is work that requires not only professional skill and sound judgment, but personal courage, emotional resilience, and a genuine commitment to the welfare of the children and families involved, even, and perhaps especially, in situations where that commitment puts the worker at odds with adults who are angry, frightened, or in crisis. Social workers in child protective services roles do not work in safe or comfortable environments. They work in the most volatile and emotionally charged situations that family life produces. They do so because they believe the work is necessary and important, and because the children they serve have no other advocates. Laura Sobel was one of those social workers. She was 48 years old in the summer of 2015, a woman who had dedicated her professional life to the work of child welfare in Vermont over a career that spanned many years and encompassed countless families, countless children, and countless situations of difficulty, crisis, and occasional resolution. By the accounts of her colleagues and the people who worked alongside her at the Bar DCF office, she was a dedicated, compassionate, and deeply committed professional who brought genuine care and skill to her work. She was known not as a bureaucrat going through the motions of a caseload, but as a person who invested herself in the outcomes of the situation she was assigned to, who took her responsibilities to the children and families she worked with seriously and personally, and who represented the best of what public service in the child welfare field can look like. On the morning of August 7, 2015, Laura Sobel walked out of the Vermont Department for Children and Families office in Bar on her way to whatever the rest of her workday held. She did not know she was being watched. She had no reason to suspect that someone was waiting for her outside the building. She had done her job. She had followed the legal and professional processes of her agency. She was, by every measure, a civil servant going about her work. Jody Herring was 43 years old in August of 2015. She was a woman who had recently been through the Vermont Child Protective Services process and had lost custody of her young daughter as a result of that process. The loss of a child through the child welfare system is, by any measure, one of the most painful experiences a parent can endure, even when, as is often the case, the removal of the child is necessary for the child's safety. The grief, the anger, the sense of loss and injustice that such a proceeding can produce in a parent are real and powerful emotions. Vermont's courts and social services system are designed to process these situations with care, to provide due process to parents, and to ensure that removal decisions are grounded in the evidence of a child's safety needs. Jody Herring's response to the loss of her daughter, as investigators and prosecutors documented it in the months and years following August 7, 2015, had gone far beyond grief and anger into something that law enforcement professionals recognized as profoundly dangerous. She had made decisions. She had formed intentions. And on August 7, 2015, she acted on those intentions in ways that left 4 people dead across 2 crime scenes in Washington County, Vermont. What is documented in the investigative record and in the court proceedings that followed is this. Before Jody Herring drove to the DCF office in Bar to wait for Laura Sobel, she had already traveled to the nearby town of Berlin, Vermont, and she had already killed 3 people. Her aunt, Julie Falzerano, her cousins, Regina Herring and Rhonda Herring, 3 members of her own family, killed in Berlin before she drove to Bar and waited outside the DCF office for a social worker to walk out of the building. Investigators and prosecutors determined that Jody Herring believed her family members had been the source of the reports to Child Protective Services that had led to the custody proceeding involving her daughter. Whether that belief was accurate or inaccurate, well-founded or a product of distorted thinking, is ultimately a secondary question in the face of what she did in response to it. She drove to Berlin. She killed Julie Falzerano and Regina and Rhonda Herring. She got back in her vehicle. She drove to Bar. She waited outside the DCF office. She shot Laura Sobel. 4 people were dead before the morning of August 7, 2015 was over. 3 of them were members of Jody Herring's own family. The 4th was a public servant who had done her job and walked out of her office without any way of knowing that doing so would cost her her life. The response across Vermont was immediate and profound in a way that few criminal events in the state's recent history had produced. The murder of a state social worker outside a government office in broad daylight was not simply a violent crime in the statistical sense. It was an act that struck at the fabric of public service, that sent a message, whether or not it was the message Herring intended, to every person in Vermont who worked in child welfare and social services, in any field where professional decisions intersect with the anger and despair of people in crisis. The grief of Laura Sobel's colleagues at the Bar DCF office was not only personal, but institutional. a reckoning, conducted in the immediate aftermath of unbearable loss, with the vulnerability that their work created and the risks that came with a job description that no training manual had fully prepared them for. Vermont Governor Peter Shumlin spoke publicly about the killings. DCF officials addressed their staff. Social workers and child welfare professionals across Vermont attended vigils, shared memories of Laura Sobel, and grappled in their own ways with the reality that the work they did could place them in situations of genuine physical danger. The broader public discourse about the safety of child welfare workers, which had been ongoing at a national level for years, arrived with sudden and terrible urgency in Vermont on August 7, 2015. Law enforcement moved rapidly. The Vermont State Police, the Washington County State's Attorney's Office, and multiple supporting agencies coordinated the response to a criminal situation of extraordinary scope for murder victims, 2 crime scenes, and a perpetrator who was identified quickly and apprehended. The investigation was thorough and wide-ranging, assembling the full picture of what had happened in Berlin and in Bar over the course of that August morning and building the evidentiary record that would support the criminal charges to follow. The legal proceedings that followed were extensive and consequential. In July of 2017, nearly 2 full years after the killings, Jody Herring entered guilty pleas before the Washington County Superior Court. She pleaded guilty to 1 count of first-degree murder for the killing of Laura Sobel. She pleaded guilty to 3 counts of second-degree murder for the killings of Julie Falzerano, Regina Herring, and Rhonda Herring. These pleas represented a formal legal acknowledgement, entered before the Court of Record for Washington County, Vermont, of what Herring had done on August 7, 2015. On November 15, 2017, Washington County Superior Court convened for sentencing. Jody Herring was sentenced to life in prison without the possibility of parole for the first-degree murder of Laura Sobel. She received additional sentences of 20 years to life for each of the 3 second-degree murder convictions. The sentences were structured to run consecutively, ensuring that Jody Herring would remain incarcerated for the remainder of her natural life. She will never leave prison. The Washington County Superior Court, acting through the formal processes of Vermont law, ensured that the consequences of August 7, 2015 were as permanent and as final as the harm that day had produced. The sentencing brought a formal legal conclusion to the proceedings, but it did not, and no court proceeding could, bring closure to those who lived through what happened and carry its consequences every day. Laura Sobel's family, her colleagues at the Bar DCF office, who returned to work in the same building where she had once worked, who passed the parking area where she was shot. The families of Julie Falzerano, Regina Herring, and Rhonda Herring, 3 people who were killed not because of anything they had done, not because of any direct role they had played in the events leading up to August 7th, but because Jody Herring had decided they were responsible for her loss and had acted on that decision with lethal force. The case prompted sustained and serious policy discussions in Vermont about the safety of child welfare workers, about the protocols governing the assessment of threats to workers, about the physical security of DCF offices and the environments in which social workers conduct their most sensitive and potentially volatile work, and about the systems in place to support workers who are dealing with situations that carry potential risks to their personal safety. Vermont's legislature engaged with these questions. The Department for Children and Families commissioned reviews of its safety protocols. Law enforcement agencies and DCF collaborated to develop improved threat assessment and worker protection systems in the aftermath of Laura Sobel's death. These policy responses were necessary and important. They were also, in the most fundamental human sense, a recognition that Laura Sobel's death had exposed a gap between the demands placed on child welfare workers by their jobs and the protections afforded to them by the systems within which they worked. That gap is not unique to Vermont. Child welfare workers across the United States have faced violence, threats, and dangerous situations as a consequence of their professional responsibilities, and the question of how to protect them while preserving their ability to do their work in communities, in homes, and in the face-to-face encounters that the job requires is a national challenge that no state has fully resolved. Laura Sobel was 48 years old. She had spent her career trying to protect the children and families of Vermont. She went to work on an August morning and was murdered for doing her job. She deserved to live. She deserved to complete her career, to see the outcomes of the work she had invested herself in, to experience the years ahead that her dedication and her service had earned. Every one of those years was taken from her by a single act of violence in a government parking lot in Bar, Vermont. Julie Falzerano deserved to live. Regina Herring deserved to live. Rhonda Herring deserved to live. All 4 victims of August 7, 2015 deserved to go home that day. None of them did. And the Vermont legal system, through the investigations of the Vermont State Police and the Washington County State's Attorney's Office, through the proceedings of the Washington County Superior Court, through the guilty pleas and the sentences entered on November 15, 2017, worked to ensure that every aspect of what happened on that day was documented, adjudicated, and answered with the full force of Vermont law. The case of Jody Herring is verified and confirmed through the reporting of the Seattle Times, the Associated Press, Vermont Public Radio, the Burlington Free Press, and the permanent records of the Washington County Superior Court. It is the most widely covered and most consequential criminal case in Vermont's recent history. A case that encompassed 4 murders, 2 crime scenes, 2 towns, 2 years of legal proceedings, and a sentencing that guaranteed that the woman responsible would spend the rest of her life in a Vermont prison. Laura Sobel, Julie Falzerano, Regina Herring, Rhonda Herring. For people whose lives were taken on the same August morning by the same person. Their names belong in the permanent record of Vermont's history. Their stories belong in the public consciousness of the state they called home. And the Washington County Superior Court, acting through the processes of Vermont law, did what courts are built to do. It heard the evidence. It accepted the pleas. It imposed the sentences. And it preserved, in the permanent legal record of Washington County, Vermont, the complete and irrefutable truth of what happened on August 7, 2015. That is where Vermont Dark Secrets ends. Not with comfort, not with easy resolution, but with the truth, verified, documented, placed into the record where it belongs, and spoken aloud so that the people who were lost are not forgotten and the communities that mourned them know that their grief was heard. Thank you for watching Vermont Dark Secrets here on Cold Case Hour. If these cases informed you, if they moved you, if they gave you a deeper understanding of the criminal justice system in Vermont and the real human stories behind the court records, please take a moment right now to hit the like button. Drop a comment below telling us which case stayed with you the most, and subscribe to Cold Case Hour so you never miss another episode. Your support, every like, every comment, every subscription, is what makes this channel possible and keeps these important, verified stories reaching the people who need to hear them. We will see you in the next episode.